Hey folks, Dave Schneider here from the Worker Power Hour podcast. Our show recently launched our own YouTube channel where we're going to be providing videos that cover the major issues of the day from a 99% working class perspective 100% of the time. But we also want to do something for our union militants, our workers trying to get organized out there. We want to provide a series of instructional videos of strategies, tactics, best practices, equip you with the knowledge to be able to fight back and win against management and corporate America in your workplace. To that end, today I have a very important topic that we're going to go over. This, of course, is the 7 tests of just cause. We're going to talk about what just cause is, what it's not, and the 7 criteria as laid out by the NLRB for what constitutes just cause for discipline or termination. Before I go any further, I just want to say, look, I'm a shop steward of 3 years out of Jacksonville, Florida at UPS with the Teamsters. If you are a shop steward, you probably know just about everything that's going to be covered in this video. I'll say this, though. Whether you are a union worker or not a union worker, this is good information to familiarize yourself with. First off, if you're a union worker, you should definitely be familiar with the discipline article and just cause clause of your contract. Get a contract book from your steward or business agent and read over that. If you're a non-union worker, as I'm talking about this, I want you to imagine how transformational having something like this could be in your workplace, where your employer no longer has the power to arbitrarily terminate you or discipline you, and instead actually has to have a reason for it. So to that end, let's dive right in. What is just cause? I think the best way to understand just cause is to first understand what it's not. In 49 states in the U.S., you can be fired for practically any reason at all. You are what's known as an at-will employee. You work at the will of the employer. This basically means if you show up to work, your employer doesn't like your shirt that day, sorry Joe, hit the bricks, you're on the unemployment line again. It's unfair, but that's the way it is. And here's under U.S. labor law, which doesn't really protect workers worth a damn. HR departments, management, they'll sometimes create these fictions of saying, hey, we've got a 30-day or a 60-day probationary period here at this job. So once you get through that, we'll bring you on full-time. You'll be a permanent hire. You're good as gold. It doesn't work like that. These probationary periods that they develop, if they're not backed up by a union contract or a contract of any kind, they're completely worthless. Just as a point, Montana is the only state in the United States that has what's known as just cause laws on the books, meaning that if you're a worker in Montana, you can't be fired except for just cause. It's actually a great thing. I'd love to have it in every one of the 50 states, especially in Florida, but we don't have it yet. It's something that we definitely ought to fight for. Hell, maybe sometime on the Worker Power Hour, we'll bring on a militant union leader from Montana and talk about how they got that and how it works in practice. But, what you need to know is that just cause clauses basically mandate that the employer has to have a reason, and it better be a good reason, for disciplining or terminating an employee. This 7 test criteria is used widely to win arbitration cases at the NLRB by different unions. But I'll just tell you this as a shop steward, it's very useful locally too for arguing and defending coworkers against unjust discipline. I'm going to just say this too on the outset. I'm going to be drawing in this video pretty heavily on a piece written by the United Electrical Workers that's on their website about just cause. I'm going to link to it in the comments section, the video description. And I'd highly recommend, if you're interested in learning more, go ahead, check that out. You can even follow along with me as we're going through. So let's dive right into the 7 tests of just cause. So employee gets into hot water with management and they decide to discipline him. That discipline, if you are protected by a just cause clause in a contract, has to meet these 7 tests. The first one, let's go ahead. Is it a reasonable rule or work order? Is the order reasonably related to the safe and efficient operations of the employer? Does the work order have any real motivation, or is it just petty nonsense? I'm going to go ahead and give you an example. The United Electrical Workers website actually has a really good one on there, and I'm going to introduce you to our protagonist for all of these examples that we're going to be breaking down for the duration of this video. We're going to be talking to Johnny B. Good, a good dues-paying union member, 25 years. He stands up to management and fights back, but he seems to get into a lot of shit, a lot of sticky situations, and we are going to figure out how to get him out of each and every one of them. So Johnny Be Good shows up to work, and his employer is mandating that everybody show up and that they wear a red shirt, that it's tucked in whenever they are at the assembly line. It must be a red shirt and it must be tucked in. Well, Johnny Be Good shows up. His shirt's tucked in, but he's wearing a blue one that day. Manager shows up and says, Johnny, you are suspended. You broke our work rule. You're not wearing a red t-shirt. Okay, you know what? That is an unreasonable work order. Johnny Be Good is probably not going to be suspended if his union does their due diligence. Johnny Be Good's going to be just fine, because the difference of having a red shirt or a blue shirt on the assembly line, it has nothing to do with safety. It doesn't have anything to do with the efficiency of the operation. It's not even a dress code. He's not interacting with customers. No, this is a completely arbitrary, made-up, unreasonable rule. Johnny's going to be just fine. Let's move on to number 2. Notice, was the worker adequately warned of the consequences for their conduct? Notice, by the way, can be written or it can be oral. Sometimes it depends on the nature of what's being noticed. But, it can be passed down either way. And some changes in policy by employer can fall under past practices and must be bargained with the union. I know in the UPS contract, any change in operations needs to be bargained with the union. Honestly, oftentimes the employer will change a particular operation or a practice of that nature, and then they'll want to discipline a worker the next day, without giving them any kind of adequate notice, oftentimes without bargaining. Now, that's a whole separate issue, but I'm going to go ahead and give you kind of a basic example. Let's say Johnny Be Good really likes to chew gum at work. Every morning he, stops at the 7-Eleven on his way to work, buys a little pack of Juicy Fruit and brings it into work. It's just his thing for whatever reason. So, his manager just really doesn't like him for some reason and just decides, we're banning gum chewing. There's going to be absolutely none of that taking place. Now, Johnny Be Good's not spitting it out. He's not littering, in any which way in his workplace. He disposes of it the right way. But management just says, you cannot chew gum here at all. So he shows up the next day. Maybe he heard the work rule. Maybe he didn't hear the work rule. He shows up the next day and they say, Johnny, you're suspended. You're chewing Juicy Fruit right now. Guess what? Johnny's probably going to be okay, because he didn't get adequate notice and he wasn't given the consequences adequately for, what it would mean to show up to work and still be chewing gum the next day. Okay, that's not adequate notice. It's not reasonable. Now, there are exceptions for egregious, serious misconduct. Like, for instance, an employer probably doesn't have to tell somebody not to use physical violence and fight in a workplace, or not to show up pissed drunk for work every morning. These are pretty basic things that the worker should know. But we know oftentimes management changes rules all the time that are totally unreasonable. They won't give people notice. They won't even tell them what happens if they don't do it. Maybe it's just a suggestion. Maybe it's a preference. Maybe it's an actual policy. The point is, management has to give the worker adequate notice, and they have to notify them of what the consequences are for their conduct or misconduct in this case. So let's move on to number 3, investigation. Did management investigate the so-called offense before handing down discipline? Management can't decide to discipline a worker and then investigate it. Investigations can vary in length, but you can't decide to throw the book at a worker before you've actually determined if an offense actually took place. So we're going to go ahead and take a look at an example. Let's say Johnny Be Good, he's got this boss, really doesn't like him, but he's got a wedding the next day. Let's say it's a Thursday night. He's got a wedding on Friday, and he's in it or something like that. He calls in, gives him plenty of time, follows the practice locally, calls in, and guess what? Johnny Be Good has a vacation day that he can use, and so he uses it. So his boss, Hubert Jass, he goes by Hugh for short. When Johnny Be Good shows up on Monday, Hugh storms down and he says, Johnny, you're suspended. You missed another day of work. I'm writing you up for attendance, and you're out for 3 days. Well, guess what? His boss didn't listen to the voicemail. He didn't investigate to see if a supervisor had talked to him on the phone. He didn't investigate to see if Johnny had a vacation day. Guess what? No investigation took place. That is unjust discipline. Johnny Be Good is just fine right there. Let's move on to number 4. The investigation has to be fair. This should seem pretty basic, but it's not, especially when it comes to management in corporate America. Was the investigation fair and objective? Oftentimes we know managers and supervisors like to get one side of the story. So let's say Hubert Jast, this supervisor, he runs up to management and he says, Johnny be good, I saw him, he stole a widget from my office, okay? He's just incensed, and management says, well, how do you know? And he's like, well, I have a sense, it was the look in his eyes or something like that. Well, guess what? Johnny be good works around another coworker. There's cameras all over. His coworker D's nuts. This guy didn't see Johnny be good steal anybody. And you know what? To that point, management didn't even go up to brother D's nuts and ask him if he'd seen Johnny be good stealing anything. Because if he had, brother Nuts would have said, no, I worked with him all day. He didn't take anything. I got misplaced by somebody else. He didn't go and check the camera footage. He didn't look for any kind of other evidence other than, this supervisor just had it out for this worker. That was an unfair investigation. And so to discipline Johnny be good for that would be unjust. Okay, so let's move on to number 5, proof. This is a really important one, okay? Was there substantial evidence or proof that the worker was guilty? Now, this is not quite the same as in a courtroom in the United States. Management doesn't necessarily have to prove beyond a reasonable doubt or even a preponderance of the evidence. But what they do have to offer is some kind of proof, and it better be pretty good, that an offense took place and that the worker was the one who actually committed the offense. I'm going to give an example straight out of my workplace. This happens all the time. I'm not going to go into anything with particular coworkers. This literally happens all the time, and I argue management on it constantly. Okay, I am a preloader. I load the brown trucks that go out. We get probably like 1,000 pieces a day. Some people get way more than that, up to like 1,400 pieces, packages a day. And you got to sort them, sometimes 3, 4, maybe even 5 trucks, right? Okay, misloads, which are where you put a package that's supposed to go in one car in a different car, they happen occasionally. I mean, a coworker will get one misload out of, 1,000 pieces, which is 99.9% accuracy. I just want to be clear on that. If it were a math test, you would have gotten an A++ on that. But management will want to write up a worker for misloading one package out of 1,000. Okay, so, they show up, they say, okay, we know for a fact this package showed up on this truck and it was supposed to go on this truck over here. We're pinning it on this worker. So then the real question is, well, maybe that worker had his package car drivers came in early and they helped him load his trucks. How do you know that the package car driver wasn't the one who misloaded? Let's say maybe that worker had a ton of extra pieces coming down the box line that day, just, way more than usual. They sent over another coworker to help him out. How do you know that the coworker who came over to help out wasn't the person who misloaded those packages? Or better yet, management loves to do this, especially when you get into overtime territory. They'll say, we don't want to pay overtime, get off the clock, you need to go clock out and we'll have somebody else finish up your work. Well, how do you know that the person you called over to finish up that work wasn't the person who misloaded the package? The point is you don't. There's no evidence at all. You do have proof that there was a misload that happened, but you have no proof that this worker was the one who actually did it. So that's unjust discipline, and that would get thrown out. So, okay, number 6, equal treatment. Are rules and punishments applied equally without discrimination? Basically, what's good for the goose better be good for the gander. Every employee needs to be treated the same with regards to rules enforcement and punishment. Give you an example. Johnny be good. Let's say he's got a stellar record. Actually, it really doesn't matter if he has a stellar record. Let's just say he misses a day of work. Okay. Seymour Butts, his coworker, who, maybe a real kiss ass, is late every single day, misses days left and right, never gets written up. Johnny be good gets written up. Okay, you know what? That doesn't work. Management, if they're going to apply discipline, if they're going to enforce the rules, they have to enforce them equally on everybody. They can't favor one employee that they like better than another employee, get them out of discipline, give them better conditions, etc. Discipline has to be equal, otherwise it's unjust. It doesn't meet these criteria. Okay, so let's move on to number 7. The penalty. Is it a reasonable penalty related to the seriousness of the offense and the employee's past record? So for instance, you probably can't, in most cases, get fired for being 1 minute late one time. Okay? That's not going to work. That is way overkill for the seriousness of the offense. Yeah, you were a minute late. Yeah, that happened. But is that serious of an offense to get you terminated? In almost every case, the answer to that is no. So let's use an example, okay? We're going to talk again about Johnny Be Good and Seymour Butts here. Johnny Be Good, union militant. Management really doesn't like him at all, okay? He's got a totally clean record. He's worked there for 25 years. So he was late one day in 25 years, okay? He's suspended for 3 days because his management, huge ass, walks down and writes him up and just wants to get rid of this guy. Seymour Butts, on the other hand, has a warning letter, was already suspended once for being late, is basically late again, 1 minute late again, and, gets the exact same discipline or a lesser discipline. No, that's not going to work. One, that would violate equal treatment, criteria number 6. But the other aspect of it is that the penalty is not reflective of the seriousness of the offense. It's not that big a deal if a worker of 25 years is late one time, gets suspended for 3 days. That's totally overkill. And then compared to another worker who has a record that's, out the door, Johnny Be Good doesn't even have a record. Yeah, that's not going to work. That's completely unjust discipline. So here's the deal, folks. I want to leave you all with a couple of tips. If you are a union worker and you're being disciplined by management, this is very important. You need to always ask for a shop steward. That is your legal right. The Supreme Court has guaranteed that in NLRB v. Weingarten. These are known as your Weingarten rights. Basically, if management is coming up to you and they're asking you any series of questions, or they say that they're investigating something, and you think that it could reasonably lead to discipline, then you have the right to say, I want my shop steward present for this, and then you do not have to answer any of management's questions until they get you a shop steward. Okay, that is your legal right. So if you're ever being disciplined, it's very important to get your shop steward. 1, it's another set of eyes. 2, it's a witness. 3, your shop steward is going to know the contract and be able to actually ask questions and defend you to management. So you always want to exercise your Weingarten rights if you're being disciplined, especially if you think the discipline is unjust. Okay, stewards, I want you all to remember this. Take notes, please. Make sure you have a notebook that you come into work with every day where, if discipline's going on, write down just even like who was there, what was said, etc. This kind of information can be crucial down the line, especially, if we're talking about suspensions or terminations or somebody's job. It's actually a good idea to go over these 7 criteria and think about when management issues somebody a warning letter or a suspension, did this meet these 7 criteria? And then, you want to give that to your business agent or whoever's going to be the person arguing for that worker down the road. I mean, of course, you should try and argue for them right there. I mean, sometimes it's really easy, like the misload example I brought up earlier. I mean, I've got a series of like 10 questions right off the bat anytime a worker's being disciplined for misloads that I can fire out, and 9 times out of 10, management hasn't considered at least one of them. So that's very important. The last thing I would say is that if you do get disciplined as a worker, a union worker, especially, a union worker period, but I'm especially talking to my UPS Teamsters out there, you need to file a grievance, okay? This is a grievance for my union, Local 512. This is what it looks like. Even if it's just a warning letter, you don't want that on your record unanswered. This grievance is your opportunity to be able to answer the warning letter. So if it's unjust, if there's problems with the way management went about things, you want to at least have it on the record that you protested it. So get a grievance form from your shop steward. The other thing, if it's a termination or a suspension, you're going to need to file a grievance in order to stop that process from moving forward without you getting a fair hearing. So, make sure to do that. Make sure to always grieve any kind of discipline you get from management. And you know what? If it's unjust discipline, go ahead and fire another grievance out there for harassment on them, because we know how management works. They love to harass people. If you're a union militant, they don't like you in the workplace in the first place. But, let's say they just want to meet their production numbers. They'll harass you, trying to get you to go faster. Maybe they'll hold discipline over your head. And you know what? 9 times out of 10, it's going to be unjust discipline. So these 7 tests of just cause are very important for you to understand. I hope that everybody found this video very helpful. Please tune into the Worker Power Hour. We try and put out 1 new episode a week, just to cover the major issues of the day and then do some deep dives on issues important to the working class. Make sure to subscribe to our YouTube channel. And with that, Union Power.